families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to this week's episode of Families Divided TV. Tonight, we'll have with us Dr. Lena Hellblom Sjogren, who is in Sweden. She'll be speaking to us about the human rights of children, which is so vitally important. Children have a human right to family life, and this right is violated in severe parental alienation cases. Children from other countries that have ratified the third optional protocol, which Sweden, the country she lives in, has not, can use the treaty to seek justice if the national legal system has not been able to provide a remedy for the violation. Dr. Sjogren really understands this, and I really hope you'll pay close attention to her because it's very important when it comes to our children's rights. We're going to be right back with Dr. Lena Hellblom Sjogren right after these important messages.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Thank you, Elaine Cobb, for inviting me, Lena Hellblom Sjögren. I know family is important as I am a mother of 4 and a grandmother of 8 until now. And therefore, I think I am in this field, but I have done a lot during my long life, as you can imagine. But when I became a mother past 40 with my youngest children, I decided to work from home, and then I started a company after having done a postdoctoral course in Stockholm University about interpretation theory and with psychology. So that is my background now for having worked in this field with severe parental alienation cases and research on disturbed family relations for more than 3 decades now. And I still wonder why not my colleagues and child protectors in many sectors see the harm done to children when they are deprived of their much needed contact for their own well-being with both parents, if the parents are what we call good enough. I want to tell you something about what I think is a unique system that we have in Sweden, with only social secretaries as investigators in custody disputes and decision makers, and also the ones executing their own decisions and evaluating them. This is not in accordance with Montesquieu's teaching about the division of power. In 1974, Sweden had a new constitution, and the previous constitution had a vertical and horizontal distribution of power. In 1974, this was replaced with a circular distribution of power. And the Social Services Act, replacing the old laws, then became a framework law, not a detailed law. The social services were supposed to be service-oriented at the same time as the officials within the authority given the power to interpret the law regarding their own work in the social services. In Sweden, there are no family courts. A general court decides about the children's future when one of the parents has sued the other to have sole custody, for example. An administrative court decides about the children's future when it comes to compulsory care. The officials within the social services are called social secretaries. They have 3.5 years education where they learn a little about a lot of things without any specialization, and they do not have a license to defend, and they do not have an official's liability. And you can say it's not their fault that they have not been given reliable tools for the important tasks laid upon them. The social secretaries are called family rights secretaries when they belong to the entity within the social services called the Family Rights Division. And this is confusing for many parents who come in contact with this entity because they think they are legal professionals, but they are not. They are the same social secretaries as the other ones, but they are called family rights secretaries. And they are appointed by the district court to come up with a report with recommendations for decisions about the children's future to be taken by the court. And the courts always do that, although the courts have an obligation to investigate the cases they decide on their own. These recommendations from the social secretaries that the courts usually follow have first formally been approved of and signed by the local politicians in a local social welfare board. There is no one, when business is run as usual, who ascertains that the report presented is based on documented facts or hearsay. And sadly enough, it's often hearsay, what I have seen. There is no one and nothing is authentically documented. Not even the talks with children the social secretaries are obliged to have. It's only what the social secretaries have written about what has been said by the child, by the parents, and by some reference persons they have interviewed that is referred in their reports given to the court, signed by the Social Welfare Board. And then, of course, in their report, they also have the risk assessment they are required to do, but they have not been given any risk assessment tools, reliable such ones. So it's mostly subjective judgments. Since the UN Convention of the Child's Human Rights 1989, adopted in Sweden 2020 in January, the child's human rights are sadly enough not considered when the best interest of the child is to be decided. In Sweden, this convention is referred to mostly when a child is asked by a social secretary to choose the parent that the child prefers to stay with and to be with. We know that the child's brain is not mature enough for understanding the consequences of such a choice. But for the adults involved, it's comfortable and make them feel good. They are proud of themselves as they proclaim, "We listen to the child." A social secretary in charge can judge it's best to place the child with one of the parents in a custody conflict, and place their child in compulsory care, although this was not at all the intention with the law from the lawmaker, because that law is to help and rescue children from very bad settings, or if they are dangerous for themselves. The Swedish government in March 2018 informed on the government's internet site, and now I quote, that human rights are respected is crucial for the development of a democratic rule of law. Conversely, we know that democratic decision-making processes and a functioning and legal state strengthen the protection of human rights. From my empirical studies of how disturbed parent-child relationships in Sweden are handled, it can be concluded that real life for the children involved demonstrate the opposite. The decision-making processes where officials from the social services have been given the legal power to decide do not strengthen the protection of human rights, nor the development of a democratic rule of law. If a parent is documented over time to have been a good enough parent, that parent's children shall not be deprived contact with that parent. But this happens again and again. The reports from the social secretaries are decisive for which party wins in often long custody battles between parents and in compulsory care cases where one or two parents fight against the social services. Also often in an alliance with the foster parents. This, you can say, is abuse by proxy and not high conflict. As abuse by proxy is not yet widely acknowledged or much researched, the children being victims of this kind of violence do not get the adequate help by the professionals. Instead, many professionals take, as I have described, a partial stance for one parent against the other. This happens in the severe parental alienation cases. Thus, the professionals support the child to hate and reject the formerly loved and good enough parent. Thereby, the professionals strengthen the alienation and continue the gaslighting of the parent who is being erased. And this is described in the book by Harman and Biringen, that on my initiative has been translated to Swedish. In English, it's called Parents Acting Badly, How Institutions and the Society Helps Alienating a Child from their loving families. In a report from 2 years ago by an authority for equality in Sweden, with lawfully enough 97% of the employees being females, it said something important, and that is that many courts wrongly interpret domestic violence as high conflict and thus fail to protect the victimized party. And that party can be a mother or a father and always harms the children involved. In an article from the 18th of January 2 years ago about post-separation legal abuse, a similar message was given. I quote, "Frequently, the domestic abuser creates a gaslighting narrative that the other parent should lose much or all of their parenting time because they are mentally unstable. The domestic abuser may also allege that the targeted parent is trying to undermine the role of the domestic abuser in the children's lives and raise the specter of parental alienation." End quote. Parental alienation is real. It's not a specter. The text above actually describes what happens in severe parental alienation cases. The alienating parent gaslights the other parent by degrading that parent and argue with false accusations. Hence, they argue that the degraded parent shall lose much or all of his or her parenting time. Such domestic abusers, be they fathers or mothers, acting as if the child needs to be protected against the other parent and getting support for that by seeking allies among professionals, violate the child's human rights and thereby also the rule of law. And now I just want to take the essence from some of the child's human rights that are violated in the domestic abuse by proxy cases. And first, it's Article 3 saying that the best interest of the child shall always be a primary consideration. And then I just want to make my comment here that in Sweden, the translation of the child's best interest is only the child's best. And this is often defined by the social secretaries. But the child's best interest can be generally defined as the child's legal and human right to family life, to good enough care, and to keep his or her identity without being subjected to any kind of abuse or being detained or abducted, and not ever be asked to choose between the parents because the child's brain has not reached the maturity required to understand the consequences of a decision in such a complicated and life-changing matter. Now back to more of the human rights articles that are violated when it is decided what is best for the child by a social secretary without the tools for such decisions and on her own, not in a multi-professional team. Article 8, the right of the child to preserve his or her identity. That is a crucial article. Article 9, a child shall not be separated from his or her parents against their will. And then it comes to decide what a child's will is. And that's my comment now, because it can be very complicated if the child has been severely alienated and thus mentally kidnapped, you can say. So the child can't express a child of its own because the child has an enmeshed relation with one of the parents who has taken control, for example. So then you can't trust what the child says when the child says, I want this, I want that. And you know that children want different things, different times, and they can't understand the long-term consequences. Article 12 is about the child's right to form his or her own views and to express these views freely in all matters affecting the child. And freely is the real important word in this article, because when you are mentally kidnapped by one parent, or when you have been taken into compulsory care, although your parents are good enough, then you don't feel free to express your own views, because you know you can be punished if you do. And you can also be in the situation where you have splitted yourself to survive. Article 16 is about no child shall be subjected to arbitrary or unlawful interference with his or her privacy, family, home, or correspondence. Article 18. Both parents have common responsibilities for the upbringing and development of the child. Article 19. The child shall be protected from all forms of physical and mental violence. And as we know, it's mental violence to mentally kidnap a child, as is done in the severe parental alienation cases. Back to abuse by proxy. The child's human rights mentioned above are violated when the child is being used by a domestic perpetrator who has his or her own interests in winning over the other party and uses the child as a weapon against that party. This is, as I have understood it, the essence of abuse by proxy. It is well described in an updated article, August 29, 2023, from the source called Very Well Mind by a person called Julia Childs and reviewed by David Sussman. And now I quote rather long excerpts I've made from this article because I find the article very important. Quote, abuse by proxy is another term for the emotional abuse that occurs in domestic and intimate partner violence. This emotional abuse occurs when an abuser inflicts harm upon the victim through third parties. And examples of abuse by proxy include spreading lies about the victim to their friends and family, sabotaging their career by communicating with their employer and even calling upon the authorities equipped with false information. The perpetrator may turn the victim's children against them in some circumstances. Each of these examples functions as a way to intimidate, isolate, and inflict punishment upon the victim. Sometimes this form of abuse can result in humiliation, thus resulting in the victim's self-esteem becoming significantly impacted. It's worth noting that abuse by proxy is an under-researched phenomenon with minimal scholarly articles recognizing this form of emotional abuse under the term abuse by proxy. The perpetrator isn't directly causing harm, but instead uses others in proximity to the victim to inflict damage, making it abuse by proxy. The perpetrator then ends up having increased control over the victim. First and foremost, remember that someone who loves you would never work to have others harm you. Reaching out to the domestic violence hotline is a way to start turning towards help. End of the long quotes I have made from this article. And my hope is that targeted parents, be they mothers or fathers, being the victims together with their children in severe parental alienation cases and in also compulsory care cases, unfounded, can in the future get help from the many hotlines and shelters that have been created in many countries. Helplines are listed in the winter issue 23-24 of the magazine Contemporary Family, edited by Mark Rosemont, a person who in many ways worked to preserve family ties. I now want to go to a Swedish example. It's about a girl I call Eliza and her mother, victimized by the father as the domestic abuser, supported by the authorities. And this, in Sweden, these authorities figures are the social secretaries. A district court in the beginning of 2024 decided that Eliza should live with her mother, as she had done before for 10 years, then with a regular contact with her father. Eliza's father, who through the support from the social services in the autumn last year had been granted sole custody in an interim decision, had thereafter demonstrated that he was unable to provide care for the child, and therefore the social services had decided to place Eliza in compulsory care with a woman chosen by them, and a woman strange, a foreigner to Eliza. This in Sweden is called a family home, or as in this case, a treatment home. As was pointed out by a sociologist in the social state projects in the 1990s, it's cynical to take children from their own family, as I keep pointing out, under the assumption a good enough family, and place them with well-paid strangers and call their homes family homes or treatment homes. When the mother in the district court this year was awarded sole custody, the social services, contrary to this court's decision, decided to place Eliza in continued compulsory care in the foreign woman's home. The social secretary still judged the mother to be that very bad person Eliza's father had told them she was, based on his false accusations about the mother being mentally ill or mentally disturbed, a drug addict, and violent. The social secretary in charge of this case, the same day she had heard from about the verdict, submitted a so-called proposal for a decision to the Social Welfare Board about compulsory care at a place unknown to the mother and no personal contact for Eliza with her mother. The social secretary in charge and her colleagues in the social services thus kept supporting the father against the mother as they repeated the father's false accusations against the mother. In other cases, it can be the opposite, that is, a tunnel viewing resulting in support for a mother against a father, with the same kind of repeated confirmatory biased decisions as in this case. The proposal from the social secretary in charge for a decision to be taken by the Social Welfare Board thereby became a legally binding so-called democratic decision as it was signed by the board. It means that the local politicians became formally responsible for the decision to hide the child from the parent to whom the district court had awarded sole custody, and to not allow the child to meet with her legal custodian and guardian, the mother, in this case. The father who lost custody of Eliza, according to the district court's decision, was by the social secretary in charge given the right to speak freely with Eliza and to contact her without any restrictions. The partial support, or in this case the father against the mother, is a violation of the court verdict and severe violations of several of the child's human rights and the rule of law, as well as of the fundamental law requiring impartiality and objectivity from all officials, from all authority figures. I now read from a source called Helping Survivors about common forms of abusive litigation. A among which are mentioned what can be applied to Elisa's case. An abusive litigator is filing for protection orders against you and your friends or family. I quote now, starting custody battles, refusing to obey court orders, forcing you to spend time and money to enforce the orders, falsely claiming you use drugs or alcohol. End of quote. Elisa's father has sued for sole custody 3 times and filed for protection for Elisa against her mother, refused to obey court orders, and he has falsely claimed that Elisa's mother was using drugs and alcohol, suffering from mental illness, and also of having been violent against Elisa. None of this is true, as the mother has proved through giving the social services test results from certified laboratories, statements from 2 independent psychiatrists, and documentation from the police, having interviewed Elisa when Elisa told about her father's violence when she grew up. So I have seen court orders against the father from earlier life. When the father restarted litigating to have sole custody 3 years ago, Elisa expressed that she wanted to live with her mother. She told the social and family rights secretaries, the school counselor, that her father didn't give her food and that he couldn't support her to come in time to school and other routines in her daily life. At that time, only the school counselor listened, but the social services did not listen to the school counselor. All other adults, those with power, did not listen to Elisa at that time. Now they listen to Elisa when she says that she does not want to be with her mother. Elisa's mother recently found out for the very first time when she had got access to the journals kept by the social services that Elisa, in the beginning of her father's litigating for sole custody 3 years ago, had actually complained to the discrimination ombudsman, not only to the school counselor and the others I told about. In this complaint to the discrimination ombudsman, Elisa had told about having been sexually abused also by her father. If Elisa, at the time when she was not as now mentally kidnapped, had been informed about the 3rd optional protocol to the Convention on the Rights of the Child, allowing children to submit complaints, appeals, and petitions, and if Sweden had ratified and adopted this 3rd protocol to the UN Convention of the Child's Human Rights, as they have not until now, then Elisa could have appealed to the UN. The mother reported the abuse by proxy she and Elisa were experiencing to the police and forwarded the documents proving that she had been severely falsely accused by the child's father and the social secretaries who had chosen to believe his accusations against the mother. The police and prosecutor decided to do nothing. The mother, after she had been awarded sole custody by the district court, was told by the social secretary in charge that she can file complaints to the administrative court. This court almost never takes a decision that is not in accordance with what the social secretaries have suggested. So now to the finalization of the severe abuse by proxy. The social secretaries in charge, having informed the mother that Elisa has said to the treatment mother that it's her will to not have any contact anymore with her mother. Elisa is since summer last year not allowed to speak freely with her mother on the phone, let alone meet her. Eliza hears only negative things about her mother as the social services keep repeating the unfounded accusations from Eliza's father. Eliza, isolated from her mother, has no possibilities to correct what is said. She is not allowed to get her own impressions and experiences with her mother. This case illustrates that the social secretaries can exploit the legal system to win against the parent they have judged as the bad parent. Or it can be two parents, as in compulsory cases where the parents are good enough, thereby supporting and strengthening the other parent's domestic abuse by proxy. And you can say the social services domestic abuse by proxy when they work against the child and thus harming the child involved. The practice in Sweden does not live up to what is reasonable to demand of a democratic state governed by the rule of law. This was pointed out by law professional Siv Westerberg in Sweden's biggest daily newspaper in an article, the 20th of January 1997. Siv Westerberg, who is now 92 years old, demanded a change of the law to make it much more difficult for the social services to take children from their own families. Siv Westerberg appealed 10 times to the European Court of Human Rights, and in 7 of these cases it was ruled according to her complaints that Sweden had violated the child's human right and the parents, in some cases, also human right to family life and other articles, but this was the head article that was violated. Today, when I record this talk, it's the 26th of March, and the Swedish government has today decided to give an investigator the task to reform the education of social workers. I hope it will result in something good for the children, an understanding of the importance for the child's own well-being, that preserving the child's family ties is fundamental. Without unconditional love from their loved ones, children can't develop empathy. And this has consequences we must start considering, because family and empathy is fundamental to building a human society. And it still says in the UN Convention on Human Rights from 1945 that the family is the ground stone for a human society in a democratic state. Personally, I think cutting off half of the family root system for a child, as is done in severe cases of parental alienation. I have it on my book here called The Child's Right to Family Life. I have a tree with a root system. If you cut half of it, or if you cut the whole system as is done in compulsory care cases, can be seen connected with the growing numbers of shootings and bombings we see daily in Sweden these days. I don't know if you've heard about it, but there are daily bombings and shootings in Sweden nowadays. I ask myself, what happens with the child whose identity has been taken away? With the child who has been forced to split? Where does that child seek identity? In criminal communities or in extremist groups of different kind? So I wrote this little text or poem, I don't know what you can call it. The secret, we think, is in the dark, but it is in the light it hides. The quivering light of day that makes us blind. For this shooting at night, perhaps from them whose roots were cut. Thank you for listening, if you have listened, and goodbye from me, mother and grandmother in Sweden, called Lena.
Next week on Families Divided TV, Dr. Lynn Steinberg discusses saving our children from being murdered, the need for risk assessments in the court.